Ben, can you hear me?
Yes.
Okay, I can hear you typing.
Okay, great.
Okay. Okay, we're going to go ahead and get started. Welcome to the final program in our webinar series, Cannabis Rocky Mountain Highlights for Healthcare Providers. I'm Kathy McCartney from the Skaggs School of Pharmacy and Pharmaceutical Sciences. We really appreciate your continued participation in this webinar series and welcome you if this happens to be your first time. So before we get started, we have a couple of housekeeping details. Please mute your computer, or if you're on the phone, you can hit *6 for the mic. Use the chat function in the lower right-hand corner of the screen to send in questions. You can send the questions, your questions to Ben Westergaard, and then he will relay them to the speaker. If you're calling in, please send your name and the email you registered with and phone number to sop.continuingeducation@ucdenver.edu for verification of your participation. Sometimes we can't tell who people are just from their phone number. You'll receive an email tonight after the session with an access code and instructions for completing the evaluation. I do want to let you know that we're going to be having a follow-up free webinar on Wednesday, October 12th to conduct a focus group to get more information about your interests and needs for further education related to cannabis. We'll send an announcement to all of those who have participated in at least one of these cannabis webinars. So I'm now happy to introduce Dr. Sam Kamin, Vicente Sederberg Professor of Marijuana Law and Policy at the University of Denver. Dr. Kamin holds a JD and PhD degrees from the University of California, Berkeley. His research interests include criminal procedure, death penalty jurisprudence, federal laws, and constitutional remedies. Over the past few years, he has become one of the nation's leading experts on the regulation of marijuana. In 2012, he was appointed to Governor Hickenlooper's task force to implement Amendment 64 and worked on the ACLU of California's Blue Ribbon Panel to study marijuana legalization. Dr. Kamin has disclosed that his professorship at the University of Denver is sponsored by the Vicente Sederberg Law Firm, which represents both public and private clients in marijuana cases. Dr. Kamin will be glad to take questions during this talk. We still need you to send them by chat, and then I guess we'll relay the question to him, to Dr. Kamin. So we'll now turn the mic over to Dr. Kamin. Thanks.
Thank you very much. It's a pleasure to be here. I appreciate being asked, and I am thrilled to be here this evening to speak with you about state and federal marijuana laws. I hope everyone can see the slideshow that's now beginning. As was mentioned, I am the Vicente Sederberg Professor of Marijuana Law and Policy. My background is that I come at marijuana regulation from a federalism point of view. So what originally interested me about this area is the tension between state and federal laws and the consequences that that has both for our citizens here in Colorado and for the regulatory regimes that we're able to put in place. As was mentioned, this interest got me appointed to Governor Hickenlooper's task force to implement Amendment 64, and I served on a similar body in California that was co-chaired by Lieutenant Governor Gavin Newsom there. So I have been studying both the constitutional law and the sort of public policy and regulatory questions that are raised by marijuana law and policy, and I would be happy to discuss any of those as we go through. As was mentioned, I'm happy to take questions if things are unclear or if there are questions along the way. And I will try and stop about 8:20 in order to have time for questions if there are any. In terms of full disclosure, I am the Vicente Sederberg Professor of Marijuana Law and Policy. Vicente Sederberg is a law firm here in town that represents both public and private marijuana clients. That is, they represent both government organizations and clients that appear before those government organizations. While they provide me with money to help fund my research, they do not have any editorial involvement in my work. I don't consult them before I give talks like this, and I'm pretty sure they do not know that I'm doing this. But in just full disclosure, I wanted to get that out of the way at the outset. The learning outcomes that I want to achieve this evening are as follows. I'll explain that marijuana currently in the United States is both permitted by state law in now 25 states plus the District of Columbia, at the same time that it is prohibited by federal law. I'll demonstrate that this fact means that even in Colorado, individuals who are using marijuana or who are dispensing marijuana are subject to prosecution and arrest, but that is only one of several consequences of federal prohibition. I will go into some depth on those. Finally, looking past this election into 2017, I'll talk about some possible policy outcomes as we move beyond the Obama administration. So I'll begin at the beginning with the Controlled Substances Act. While marijuana was a prohibited substance, beginning with the Marijuana Tax Act of 1937, its possession and use weren't really criminalized at the federal level until 1970. The Controlled Substances Act creates a closed system for the distribution of certain substances. DEA-registered practitioners may prescribe some of these substances to end users, and the process by which those users obtain them should be more familiar to all of you than to me, but it is that a DEA-registered manufacturer distributes it to a DEA-registered distributor who distributes it to a registered pharmacy, which is able to sell it to the end user. As we'll see, it's quite different from the way that marijuana is dealt with in a number of the states that are experimenting with marijuana law reform. The Controlled Substances Act creates 5 categories of drugs based on the approved medical uses, the potential for abuse of the substance, and the safety or possibility of dependency from use of the drug. Based on this, marijuana has been scheduled in Schedule I, the most serious, where it takes its place alongside drugs such as heroin and LSD. For Schedule I drugs, these are drugs that cannot be prescribed or distributed by anyone who is DEA licensed. So unlike the other 4 schedules, this is one where all distribution is prohibited. The possession, manufacture, and distribution of all Schedule I narcotics is criminalized, and the Controlled Substances Act provides for very significant criminal penalties. The large warehouses of marijuana that we see on the news, on TV, these are sufficient to end a person for decades in a federal penitentiary. So it's important to remember that notwithstanding everything else that's going on in the states, marijuana in all cases, in all states, in every instance, is criminal under federal law, both the possession, the manufacture, and the distribution. Okay. Furthermore, we have seen that the power of Congress to regulate, and in this case to criminalize marijuana, has consistently and always been reaffirmed. In Gonzalez against Raich, a case coming out of California in 2005, the Supreme Court held that Congress has the power to regulate drugs under the so-called commerce power, which regulates the commerce among the states and between the United States and other countries. This was unusual because Angel Raich, the plaintiff in that case, was growing marijuana on her own property in California for her own use. And she said that it was beyond Congress's commerce power to regulate what she did on her own property for her own use. The Supreme Court rejected this argument and held that such production and use impacts the illicit market, and impacts it in two ways. One is that people who are growing and consuming their own marijuana are not purchasing on the illicit market. And second, that those people who are producing marijuana themselves, that marijuana may end up on the illicit market. So this two-way street was one of the things that caused the Supreme Court to hold that even personal use grown at home was permissibly prohibited by the Congress. A few years earlier, in a case called U.S. v. Oakland Cannabis Buyers Cooperative, the Supreme Court considered the question whether it was a defense to a federal prosecution that one was using marijuana as medicine rather than selling it for profit. And the Supreme Court rejected the medical necessity defense. That is, it said, it may be that there are people for whom marijuana serves as medicine. It may be that these people are not served by other medicines. Nonetheless, Congress considered and rejected that defense, that when they chose to make marijuana a Schedule I drug, they were saying that there is no medical use of this drug, and that it is not for a court or for the Cannabis Buyers Cooperative to come to a different conclusion. That is, compliance with state medical marijuana laws is irrelevant. If you are prosecuted by a federal prosecutor in a federal court, it is irrelevant whether you act in compliance with state laws or not. We treat, under the federal law, a person who is selling marijuana for profit the same as someone who is dispensing it for medical purposes. As for the classification of marijuana as a Schedule I drug, this has been repeatedly challenged, and each of those challenges has failed. People have brought lawsuits against the DEA saying that there is no factual basis for the decision to classify marijuana as a Schedule I drug. Those have lost. Petitions by concerned citizens, by elected officials have also failed. And the DEA, after much fanfare and speculation, decided just last month not to reschedule marijuana. That is, the Obama administration will leave office with marijuana as a Schedule I drug. The DEA at the same time did say that it would make it more possible for marijuana to be produced for clinical trials. One of the real criticisms of the scheduling of marijuana as a Schedule I substance is that because it is, it's much harder to do clinical trials, which makes it much harder to show medical benefit or lack of dependency, which makes it impossible to move out of Schedule I, sort of a self-fulfilling prophecy. And that was probably the only good news to come out of the DEA's decision not to reschedule for marijuana law reform was that the federal government announced that it would be making more marijuana available for clinical trials. It also stated that it did not think of marijuana, or it no longer thought of marijuana as a particularly dangerous drug. It was going to remain in Schedule I simply because there was not a demonstrated medical use for it. While this has been happening at the federal level, we have seen the states increasingly disagree with the federal assessment that marijuana serves no medical purpose. And for the last 20 years, those states have been passing their own laws that come to a very different conclusion on that question. To date, there are now 25 states plus the District of Columbia that have passed some sort of medical marijuana law. These laws generally exempt both patients and their caregivers from existing criminal laws. But it's important to realize that this is not the same thing as legalization. What happens in medical states is that medical patients and their caregivers are given what's called an affirmative defense. That is, if they can show that it's being used for medical purposes, they cannot be convicted of possession or distribution of marijuana. They can still be arrested because their conduct is still illegal. They can still be prosecuted. And all that happens in most of these states is that at trial, they have a defense to that prosecution. So it's a relatively thin protection for marijuana patients and caregivers. That has been one of the frustrations, I think, that a lot of people have with medical marijuana. Medical marijuana laws generally require a doctor's recommendation that marijuana would be a useful treatment for the patient. And this, it's important to see, is not a prescription for reasons I laid out in the first slide. A doctor who has prescribing power cannot prescribe a Schedule I narcotic. But a doctor has a First Amendment right to discuss with a patient her options, the medicines or treatments that might be available to her, and a doctor cannot be prohibited from recommending a particular course of treatment. So the laws that have been put in place in the various states have tended to focus on the word recommendation rather than prescription, largely for First Amendment purposes. The states that have enacted medical marijuana laws have a wide range of commitment to regulating medical marijuana. As we know, Colorado has extensive laws, implemented Amendment 20, which was passed here in the year 2000. And these laws have to do with the Department of Public Health and Environment, keeps the patient registry, the Department of Revenue regulates the producers and distributors of medical marijuana. It's a very involved and expensive regulatory system. Some states, particularly in the East, have gone even further. They make it much more difficult to obtain medical marijuana. There are fewer conditions that qualify. There are fewer doctors that qualify. There are limits on the way that marijuana can be consumed. For example, a number of states ban smoked marijuana as medicine, only allowing it to be vaporized or taken in extracted form. At the other end of the continuum, California has not implemented particularly robust medical marijuana laws, and this is ironic because they were the first state back in 1996 to pass medical marijuana, but it was not until last year, 2015, when they finally enacted their first statewide medical marijuana regulations. Until that time, it had been sort of slapdash local control and relative disorganization. And in anticipation of a full legalization initiative in 2016, California finally got serious last year and began regulating medical marijuana more carefully. Other states have enacted CBD-only laws, which continue to prohibit substances with a measurable amount of THC in them, but permit CBD-based products, particularly as those have been proven useful for children and others who have seizure disorders. I find these laws relatively cynical because while they permit someone to possess CBD, they don't provide any legal way for them to get it. So essentially those people can come to Colorado, can purchase CBD products here, and then take them back home in violation of Colorado law, federal law, and the other laws. So, I think that this is sort of a stopgap measure, as in a way are all of these medical laws. I think CBD laws are just particularly cynical. Along as medical marijuana has been proceeding, a number of states, beginning with Colorado and Washington in 2012, have said, we think marijuana should be a choice that adults can make, that we don't think a person should need to demonstrate a medical need. We don't think a doctor should have to recommend it. We think it should simply be made available to all adults. And these states implemented market-based regulatory approaches. That is, they licensed producers, for-profit producers, to produce it. And in much the way that Colorado regulated the medical apparatus, the states have begun to do the same thing with recreational. Alaska, Oregon, and the District of Columbia followed suit in 2014. The District of Columbia was prohibited by Congress from regulating marijuana, from permitting stores and grow facilities to be implemented, but Alaska and Oregon are following the lead of Colorado in putting putting regulatory regimes in place. It's really important to see the ways in which this is different from medical laws. Not simply because no longer is a doctor's recommendation necessary, no longer must someone be registered, but possession of marijuana by adults is simply not criminal in Colorado. If you are in possession of less than an ounce of marijuana, that is not criminal conduct. That means that you can't be arrested for it. That means that you can't be prosecuted for it. That means it can't be seized or taken from you. So in this way, there is a real and substantial difference between the medical laws and the recreational laws that succeeded them. There is a much fuller legalization that occurs with these recreational laws than we saw with medical. Marijuana, particularly recreational marijuana or adult use marijuana, will be on the ballot in 5 states this fall. Arizona, which has medical marijuana, California, the big one, as well as Maine, Massachusetts, and Nevada. California is obviously the one that most people are focusing on. California is the country's, or the world's rather, 8th largest economy. California is famous and notorious at this point for its illicit marijuana production. It provides the gray and black markets literally across the country. There is a 50-year tradition of growing marijuana illegally in the hills of Northern California. So California's effort to create a fully legal, fully licensed, fully regulatory regime for the production and distribution of marijuana will be a real test case for how effective those kinds of regulations can be. So, federal government continues to prohibit. Increasing number of states are legalizing, either for medical purposes or for all adult users. What is the relationship between those two things? How do we make sense of a substance, marijuana, that is both permitted, in fact legal in many states, and still prohibited at the federal level? The shortest answer, and the answer I encourage all lawyers to give their clients, is that marijuana is illegal always, everywhere, for all purposes. The federal government, notwithstanding all state rules to the contrary, continues to treat marijuana as a Schedule I drug. That means its production and sale are illegal. Maybe legal under state law, still illegal under federal law. The feds can prosecute anyone in any state, notwithstanding inconsistent state laws. But we have seen that actual enforcement has varied wildly. The Obama administration has, through instructions to United States attorneys, that is the line prosecutors around the country, given guidance in terms of how to deal with state legalization. Between 2009 and 2013, this guidance was very hard to follow. At first, it appeared that the Obama administration was going to give a green light and say to the states and to those working and living in those states, we no longer care about marijuana. Feel free to go ahead and regulate it instead of prohibiting it. Then they switched gears, but finally in September 2013, through the issuance of what's called the Cole Memo, the Obama administration announced a hands-off policy to marijuana in the states. So long as the states were doing a good job with 8 federal enforcement priorities, the federal government said, it would leave to the states the regulation of marijuana. It wasn't repealing the Controlled Substances Act, but it would not be enforced. What are those priorities? Well, one of the big ones is distribution to minors, that a state has to take great care to make sure that those it's licensing or permitting to grow and sell marijuana are selling it to adults and not to children. Similarly, they must ensure that marijuana produced in a state like Colorado is not being diverted out of state to states where it's still illegal, states such as Oklahoma and Nebraska, and we'll get to them. Furthermore, marijuana should be kept separate from organized crime, from those who would use guns in the distribution of controlled substances. It couldn't be a front for other criminal activity. In general, the federal government wanted to be sure that the states were watching those things that were its greatest concern with marijuana trafficking. So I say that the situation we're in now is a truce and not a peace. The federal government has promised for now that it will not enforce its criminal laws in those states with robust regulations for marijuana. That's incredibly helpful, particularly from a clarity perspective, from those who are trying to comply with the law. But it's good only until it's not. That is, a statement by the Obama Justice Department can be reversed. We have seen 3 such statements from the Obama Justice Department. First a green light, then a cautionary light, then something of a green light. It's important to realize that once the Obama administration leaves office, a new attorney general and a new president will come into office, and they may have very different priorities. Furthermore, a statement like the one that has come from the Obama Justice Department both does not and cannot legalize marijuana. Only Congress can do that. Only the DEA can choose to reschedule marijuana. The president, through the enforcement of criminal laws, simply can't legalize marijuana. One thing that's interesting that's happened within the last year or so is that Congress has forbidden the Justice Department from spending money to enforce federal marijuana laws in those states that have medical marijuana laws. So this is more than just a guidance from a prosecutor. This is a statement by Congress, signed by the president, that money can't be expended, that the Justice Department simply cannot enforce these laws. Again, that gives more predictability, that gives more certainty, but because it's part of a yearly spending bill, it's only good for 1 year, and the most recent enactment, Section 542 of the spending bill, is good only through the end of this month. Furthermore, a number of interested parties have filed suit against Colorado, for some reason only Colorado, to try to enjoin our marijuana regulations. Probably the one most people are familiar with is the suit that Oklahoma and Nebraska brought against Colorado, that should say Colorado, not the U.S., against Colorado in the United States Supreme Court. This was a lawsuit that was brought, Oklahoma and Nebraska said, because they were being injured by diverted marijuana grown in Colorado, regulated in Colorado, but being shipped out of state. The United States Supreme Court chose earlier this year not to hear that suit, but Oklahoma and Nebraska have now sought to join another suit being brought by private citizens. So we have had both private citizens and Colorado and neighboring sheriffs have brought suit to enjoin the enforcement of these regulations, saying that they are preempted by federal law. That is, that the federal government has spoken and the states are not authorized to permit that which the federal government prohibits. For reasons I could go into in some depth, they get a little arcane. I believe that both Oklahoma and Nebraska, as well as these private citizens, are wrong. That the federal government may prohibit marijuana, that's true, but they cannot either force the states to enforce that prohibition or prohibit the states from removing their own prohibitions. That is, the states are free to do what they wish, the feds are free to do what they wish. It's only where there's a direct conflict between those laws that preemption comes into place. So as I say, there's an uneasy truce at the moment between state and federal laws. One of the things that makes that truce so uneasy is what I call the collateral consequences of federal illegality. The fact that marijuana is still prohibited at the federal level, the fact that it is still illegal in all instances, has real significant consequences for both patients or users in the states and for those attempting to comply with state regulations. Probably the best known of these is banking. Despite something called the FinCEN memo, which was another attempt by the Obama administration to create guidance to regulators, the banks that are part of the Federal Reserve System are very wary of taking money from what they know to be marijuana businesses. As a result, marijuana just in Colorado, just last year, was a $1 billion cash business. What does that mean? That means that employees are paid in cash. That means that taxes are paid in cash. That means that energy bills, water bills, all of that is paid in cash. It means an enormous amount of cash on hand, which is bad for everyone. It's bad, obviously, for the regulated entities because it makes them a target for criminal conduct, but it's also really bad for regulators. the Colorado Department of Revenue is tasked with making sure that taxes are paid, is charged with making sure that profits are not diverted to organized crime. It is much easier to do that when there is a paper trail than when all transactions are done in cash. So banking is one of these instances where the concerns of the regulated and the concerns of the regulator match up almost one-to-one. Nonetheless, despite some very smart people trying very hard to solve this problem, it remains. It is very difficult for marijuana businesses to get banking services. Taxation is one that probably gets less notoriety than these others. There's a federal tax provision called 280E, which requires those who are dealing controlled substances to pay their taxes and denies them all deductions except for the cost of goods sold. What this means is that there is essentially a 70% tax on marijuana profits, and that all marijuana businesses are subject to audit. It also creates, and this is why most people should care, odd incentives. If you're a marijuana business, the more it costs you to produce, the more you can take in terms of deductions. So the more inclination you have to increase the cost of your goods to produce more. So this tax provision has this perverse incentive. Contract is another interesting one. There's this great case out of Arizona called Hammer against Today's Healthcare, THC. The Hammers lent money to a Colorado marijuana business, knowing it was a Colorado marijuana business. THC then stopped paying on that loan. The Hammer sued them in Arizona State Court, and THC showed up and said, "We're drug dealers." They knew we were drug dealers when they lent us that money. You can't enforce a contract that's a loan to drug dealers. And the Arizona court agreed, told its citizens, "You guys are out this money." That might seem, oh, well, that's great for the marijuana industry. It's really bad for the marijuana industry. It's really bad for the marijuana industry because contract serves as an alternative to the enforcement of agreements by force. We use the courts to enforce our agreements, and that means that people don't need to resort to what we euphemistically refer to as self-help. That is, they don't need to show up somewhere with baseball bats demanding payment. More recently, there was a insurance case out of Colorado Springs where the insured lost some marijuana in one of the big fires down in the Springs and filed an insurance claim saying, "We lost these marijuana plants that were quite valuable. We would like our claim paid on that." And the insurance company said, "We can't pay that. That's contraband." The federal court in that case said, "You knew very well what it was you were insuring. You took premiums knowing that you were insuring marijuana. You were obligated to pay for that, even if it is contraband." Similarly, bankruptcy protections are not available. If a marijuana business goes bankrupt, its debts are not discharged the way others are. And while all of those apply principally to marijuana businesses, we've seen the real sort of human face of some of these collateral consequences. I think most people are familiar with the case of Brandon Coates. Mr. Coates is a paraplegic who was working for Dish Network in their telephone services. He was a medical marijuana patient. He took marijuana to help control a seizure disorder. And it was not surprising, therefore, that when he was drug tested by his employer, he tested positive. He said that he was protected by Colorado's lawful off-duty conduct statute, which prohibits someone from being fired for engaging in lawful off-duty conduct. This is often referred to as the Smoker's Bill of Rights, that sometime back in the 80s, employers didn't want to hire smokers. They had higher absentee rates. They were sick more often. They were harder to insure. And the cigarette companies passed these off-duty conduct statutes, which said you can't fire someone for what they do outside of work. And Mr. Coates, it was shown, wasn't impaired at work, that rather marijuana allowed him to work and it was almost impossible for him to work without it. Nonetheless, the Colorado Supreme Court unanimously upheld his firing. Why did they do so? They did so because his conduct, his off-duty conduct, was not legal. It was criminal conduct. not under state law, but under federal law. And that which is prohibited by law is criminal and not lawful, and therefore he was not entitled to the protections of the state statute. So that's where we are. We are in this truce where the federal government isn't enforcing federal marijuana laws in the states, but at the same time, things are not exactly rosy for those who are engaged in marijuana conduct here. There are lots of obstacles to the enforcement of state regulations, and people who use marijuana put themselves at risk. I mentioned the employment risk, but we can imagine that there are quite a few others. Anyone who receives federal grants, anyone who receives federal assistance, whether it's with housing, whether it's with student loans, those people risk losing those benefits if their marijuana use is discovered. We have seen cases of child custody where the best interests of the child are calculated in part by the fact that marijuana is present in one home and not in the other. Probationers and parolees who want to use marijuana while on release are often told that they are not allowed to do so because a standard condition of probation or parole is that the probationer or parolee commit no new crimes. Well, so long as marijuana is criminal, their use, their purchase of marijuana is a new crime. So we have this tension, and I say it's an unstable equilibrium, that it cannot go on like this, where we have $1 billion industry, all of its transactions are criminal. On January 1st, 2017, or January 20th, when a new president is sworn in, more than half the states, we know this to be true, will have medical laws on the books. The overwhelming majority of people will live in a state where marijuana is lawful. If you think about states like California, Illinois, New York, New Jersey, big states, lots of population, all of those states will have some medical laws on the books. In addition, we will have somewhere between 4 and 8, maybe as many as 9 states that have recreational laws. That is, where any adult is permitted to purchase marijuana so long as they are over the age of 21. And we will have all that happening at the same time that the federal prohibition remains in place. I, as I've said, maintain that that can't continue going forward, that something has to give. And what I think has to give is the federal prohibition, that it's possible that a new administration will come into office and that new administration will try to roll back the clock. But as I said, we have the representatives now of more than half the states and a vast majority in Congress would, I think, quite strongly resist that. But one of the real takeaways that I want everyone to have from our discussion this evening is that prohibition isn't an either or. That is, it's not that we either prohibit marijuana or allow it. As our experiments and experience in the states show, there are a number of ways to deal with marijuana that are somewhere between full prohibition and full criminalization. We have seen just in the last couple of years some initiatives in the Congress, not a ton, but a few, that would start to move the federal government away from its current prohibition. The CARES Act, proposed by Senator Booker in 2015, would begin down that path. It would make the protections of federal non-enforcement of marijuana laws more permanent. It would permit greater medical use and experimentation under federal law. Hasn't gone very far. Even less far has been the initiative proposed by Senator Sanders to end the federal marijuana prohibition. That's what his act calls for. It would take marijuana out of the Controlled Substances Act and treat it the way alcohol is treated. Amendment 64, which passed here in Colorado in 2014, was called an act to regulate marijuana like alcohol. The Sanders proposal would do exactly the same thing. It would take marijuana out of the Controlled Substances Act, it would put it in the Department of Alcohol, Tobacco, and Firearms, and it would be treated much the way alcohol is. Other proposals that have been before the Congress, and again, none of these have gotten very far to date, would exclude hemp from the Controlled Substances Act. The hemp plant and the marijuana plant that's cultivated for its THC are very distant relatives to one another. The hemp is grown with very low THC, is grown for its fiber. Marijuana is grown with complete disregard to its fiber and a high focus on increasing THC. This proposed bill would separate those and treat them differently. Other bills would make banking available for the industry, would allow for more medical testing, would make high CBD, low THC marijuana legal, the sort of marijuana for which medical use seems most promising. As positive as any of these would be, it's really important to remember that it's the illegality of marijuana, it's the criminality of all marijuana conduct that creates the collateral consequences that I spoke of. So really, if we're thinking about what to do going forward, what shape the post-prohibition could take in the U.S., it's really important to think about, well, what are some of the different models? And to remember that prohibition is not a light switch to be turned on and off, but rather there's something of a dimmer switch there. And I want to close this evening by talking about some of the parallels or examples that we can use when we think about what the right way to move beyond federal prohibition and toward federal regulation might be. So if you take a libertarian perspective and think, well, adults should have a choice of what they put in their body, that Angel Rach should be able to do whatever she wants on her property with her body and the things she grows in the soil, you might have a very non-interventionist view. You might say, well, the federal government should do very little to regulate what happens with marijuana. That is, people shouldn't be able to make false claims about marijuana's effectiveness. Marijuana that is harmful or contaminated should be removed from the market, but that generally speaking, people should be able to use it, to sell it with very minimal regulation. Here, as I point out, the closest examples are things like herbal supplements and probiotics. The federal government regulates those only to the extent of prohibiting false advertising and preventing harm. That substances that are clearly harmful can be removed from the market, but that generally speaking, the government neither endorses nor prohibits those products. A related idea that the federal government should step out of the way of the market and allow people to purchase those products for which there's demand would say that we should treat marijuana like alcohol. And this is an idea that has lots of currency. It's often said that marijuana, regardless of its medical effects, regardless of its addictive effects, is certainly less dangerous than alcohol. And there are lots of metrics by which that's true. There's no lethal dose that anyone's found of marijuana, that it doesn't impact the organs in the same way that alcohol does. It doesn't create that same sort of belligerence and violence that alcohol does. And so a lot of people have said, well, we ought to treat marijuana the way we treat alcohol. And teaching students in the law school, that's an idea that has a great deal of resonance for them. When I push back on that with them, one of the things I say is, well, look, if we were existing in a state of nature and we lined up all the substances that we knew about and said, well, let's make a list of, or let's order these from most harmful to least harmful, we might all agree, well, this plant seems significantly less harmful than that distilled product. But no one is talking about removing alcohol from the public or for making it a controlled substance. So when we talk about legalizing marijuana and treating it like alcohol, it's important to remember that it will be joining alcohol and tobacco and other products among the legal products. And so one of the things that I really encourage people to think about, and when I talk to government actors to really look at, is what are the interactions between marijuana and these other drugs? Will people use marijuana instead of alcohol, or will they use it in conjunction with alcohol? Will they use it along with opiates, or will they substitute marijuana as a painkiller for opiates? And I think that one of the really important things that we have to do is look not just at marijuana use and whether it goes up, and not just at marijuana use among juveniles and whether it goes up, but looking at the interaction between marijuana and these other drugs. Harm reduction is an idea that has a lot of currency in drug policy. This is the idea that if we believe there is a demand for heroin or other injectable drugs, that rather than trying to eliminate those drugs, rather than trying to destroy the supply of those drugs, we ought to recognize that demand and minimize the harms that are associated with it. We can do that by distributing needles. We can do that by providing safe spaces for people to inject drugs. Another way that we do that with alcohol is the Alcohol Board of Control that a number of states have. This is where the state has a monopoly on the distribution of alcohol. It has been recommended when I was on the Amendment 64 task force, one of the principal recommendations that we got from public health officials was don't let private profit-driven entities do this. Let the state do it. If people want marijuana, let them buy it from the state. There'll be less marketing, there'll be less targeting, there'll be less advertising, there'll be fewer harmful products, and the state will get all the profits from those and not simply the tax revenue. We had to reject that for a couple of reasons. One, it was simply not consistent with the text of Amendment 64, which talked about licensing private entities to produce marijuana. The other was the federalism problem that when I mentioned early on conflicts between state and federal law. The state permitting someone to do something that's prohibited by federal law, licensing people to produce marijuana, is much less of a conflict with federal law than when the state itself violates federal law. If we were to have a state monopoly on the distribution of marijuana, we would be telling state officials, you shall, as part of your job, violate federal law. That is a much starker contrast between state and federal law, and I think would cause us to run afoul of federal law. If, by contrast, the federal government decided that it made sense for the government to distribute marijuana, that is a choice that they are free to make. So the federal government will have more policy options available to it when it begins to move away from prohibition than the states themselves have. Another way we might view marijuana is as a source of revenue, and this worried a lot of people when the regulatory body here in Colorado that was put in charge of marijuana was the Department of Revenue. I talked to people that were in the industry who thought this was great. They said, great, if they look at us as revenue, we're never going away. We're a source of revenue to the state becomes dependent on us. And we've seen certain activities. The lottery used to be criminal conduct. When we talk about numbers runners, what we're talking about is people that were running lotteries illegally in this country. That conduct today is done by the state. We engage in state-run lotteries not because we think that conduct is particularly good or beneficial or that it's a particularly fair distribution of revenue, but because it makes an enormous amount of money for the states. So we've taken something that, I don't think anyone thinks is particularly laudable, and we have created a government monopoly on that. Why have we done so? For revenue generation. The other thing we could do, and this is probably, I think, the way that things are going, is to say, look, marijuana should be legal but discouraged, that people should be able to engage in this conduct, but maybe we put bans on advertising it, maybe we ban certain kinds of products, maybe we say it can't be done for profit, and that we treat it maybe the way we do tobacco or pharmaceuticals, that we say, look, this is something for which there's a demand, maybe this is something for which there is a tangible benefit, but we want to be very careful about the way it is marketed to the public. I know that almost everyone that I know is concerned about a big tobacco, a big pharmaceutical, taking over the marijuana industry. And that though these industries are heavily regulated, people think we need even more regulations. We need even more prohibitions. When I turn on a football game, all I see is ads for pharmaceuticals. That we could regulate it like these products or even more so. So, as I conclude, I really want people to take away from this discussion that, as I say, prohibition is not a light switch, and the decision to move away from prohibition is really the first regulatory decision and not the last one that government officials, particularly federal officials, are going to have to think about. What is it that we want out of regulating marijuana? What do we hope to gain from it? What does marijuana look like? Which of these other substances does it resemble? What are we happy with in the way those different substances are regulated? And to put those regulations in place. The experience of Colorado has been one of starts and stops that we, I think, have done a very good job of regulating marijuana, but it's been imperfect. When problems have been present, we have returned to them. Whenever someone from another state says, should we do this? I said, well, you should do it, but here's a couple things. One, you shouldn't do it to get rich because good regulation is expensive and you don't want to become dependent on the revenue. And two, don't think you're going to legalize it and regulate it and walk away from it. That it's an iterative process. It requires returning to it over and over. It requires careful measurement of lots of policy outcomes. And it requires being willing to say, you know, we made this decision early on. It was wrong. We need to move away from it. So with that, I'm going to pause there. I'm happy to take any questions that you have.
Hi, Sam, can you hear me?
I can.
Okay, we have one question so far, and that is, does the federal government receive any tax money collected under Colorado state taxes on marijuana?
Great. So the question is, does the federal government get any of the tax revenue that's collected by the state? And the answer is that it does not. The federal government gets income tax from those people who are involved in the industry. As I said, those people are obligated to pay federal income tax. They can't take deductions. The federal government gets a very healthy tax from those individuals. But in terms of the licensing fees, the excise taxes, the special sales taxes that are imposed on marijuana by the state and by localities, those are split between the states and localities, and the federal government gets none of it.
Great, thanks.
Sure.
Anyone else have any questions? Please send them to me, Benton Westergaard, and then I will forward them to Dr. Kamen. Okay, let's see. Another question here. Can you comment on the steps that might occur to remove marijuana from the Controlled Substances Act or to reschedule marijuana to C2?
Sure. So that can happen in one of two ways. Either it can happen by the executive deciding that marijuana should be rescheduled. That's what people thought was going to happen at the end of the Obama term. But it did not. So the DEA, in conjunction with the Justice Department, has the authority to reschedule marijuana out of Schedule 1. It has chosen not to do that. And the other is that Congress, having created the Controlled Substances Act and its 5 schedules, can move drugs among those schedules. And I think that depending on who becomes president, will probably be where the focus is in the new year. That the move will be from the regulatory agencies to the Congress. Particularly if there are 30 medical states and 8 adult use states, there will be increasing pressure on Congress to take that view of the majority of Americans into consideration in terms of regulating marijuana.
Great, thank you. Next question. Where do you personally foresee the industry moving?
Where do I foresee the industry moving? Was that the question?
Yes.
I think, these two things go hand in hand, that, if marijuana is made a Schedule 2 drug or a Schedule 3 drug, that it can only be distributed through the closed system set out in the Controlled Substances Act, I think it will start to look very much like a pharmaceutical. I think that pharmaceutical companies will be the ones that have the market advantages and will be the ones producing it. And I think that will lead to a continuation of the black market. I think most of the people I know and talk with who are interested in marijuana are not would not buy it from a pharmaceutical company, not buy it if it looked and felt like a pharmaceutical product. Other regulatory models might lead to other winners. I think that if it is treated like alcohol, then we'll have very large producers in the same way that we have with alcohol. Coors, Molson Coors, and Anheuser-Busch, and a few other very large brewers do the lion's share of the distribution of alcohol or of beer. But there are still craft brewers who make I would say, a better product and are able to attract a niche audience with higher prices and a better product. So, I think that it will not look like it looks now. I think production in any regulatory model will be bigger. I think if people are concerned about particular outcomes, whether they're advertising, whether they're for-profit, whether they're edibles, the time to buy into that lobbying effort is very soon, because I think starting with the next Congress, we're going to see increased lobbying and winners and losers getting chosen by these regulatory decisions.
Okay. And also following up on that, if marijuana were to be rescheduled as a medication, would that drive the recreational system to the black market?
I think that it would. I think that one of the things that came up when I was on the Amendment 64 task force was things like butane hash oil, which is a very concentrated 80-90% THC product made in a relatively dangerous way with butane or other solvents. And there were calls to ban it outright. And that was rejected in part because people said, look, there's a demand for this product. It's better to regulate this product. It's better to create safe procedures for this, to sell it in a way that people know what it is they're getting, than to ban it outright. Because if we ban it outright, people will continue to seek it out. I think that if marijuana is a pharmaceutical, and if, as in New York and New Jersey, it can only be gotten in pill form or vaporized, the people that enjoy edibles, the people who enjoy smoking dried flower, will continue to find those products, and you'll lose the regulatory advantage and the tax advantage of legalizing and regulating and taxing.
Okay. Anybody else have any questions?
Last chance for questions. This is Kathy again, and I just wanted to thank you, Dr. Kamen, for this presentation. It was very interesting, and it's obviously a story that's not going to end anytime soon, and we'll just have to stay tuned and pay attention to the news and see how things develop. So thank you very much, and we'll be sending out an email with information to get your CE credit and do the evaluation. So.
All right. Well, thank you very much for asking me. That was a pleasure to do it for you.
Thank you so much.
All right. Have a great
Thanks.
night.
Okay. Good night.
Bye-bye.
So I'm gonna go. Do I have this? So I'm like, so I go just replace